the Derby horses.
All right, that sounds good. I like that. I think we can do that. Let's go ahead and dive into our topic of the day, though, Mo. We've been on this for a while now, and if you've missed out on this alimony reform bill that's been going through the process here in Central Florida, the legal process, then you can go to the past shows. We've talked about it for weeks and weeks and weeks just to catch up and get into more detail and everything. But you do have an update for us on this bill here today, Mo.
Yeah, so it's the bill to end permanent alimony, and as you've said, we've been following this bill for I don't know, probably a month or so now. And the bill is now on its way to the Senate floor, but I wouldn't hold your breath just yet on it actually being passed. So it's the proposal to eliminate permanent alimony. It's headed to the Senate floor, but now it has strenuous objection of the family law section and other critics. So as we've talked about before, the main portion of this bill would end permanent alimony, which is basically alimony until you retire. Anything over 17 years in Florida, typically now, there's a presumption in favor of permanent alimony. This bill would get rid of that altogether. So you're probably saying, well, why does it have such opposition? Well, it has such opposition because, as we've seen in years past, this bill also includes a 50-50 time-sharing presumption. And there's also a portion of the bill which makes it retroactive, which basically means anyone who currently has a divorce agreement in place in Florida, this would go back and modify that, which if you're paying alimony, you'd certainly be thrilled about that. If you're receiving alimony, not so thrilled about that.
And that wasn't on the initial bill. Neither one of those things were on the initial bill.
Right. Those have kind of both been added in as this bill's been made its way through the legislature. They're both in there now. And as we've seen, the last two times they tried to get this bill through, those were both the issues that killed the bill. So we'll see if it ever makes it out of the Senate floor, frankly. But right now, the bill, the way it's written, would limit rehabilitative alimony to 5 years and bar the awarding of durational alimony for marriages shorter than 3 years. So rehabilitative alimony is exactly what it sounds like. It's just alimony to get you back on your feet. Durational alimony just means alimony for a duration, a period of time. Here, if you're married for less than 3 years, durational alimony is off the table. Right now, you can kind of do durational alimony in any length marriage, but it is unlikely in marriage, short-term marriages.
Right.
They also added a formula component to it, so durational alimony would be awarded for half the length of the marriage that lasts between 3 and 10 years. So if you're married 8 years, you're going to automatically get awarded alimony for 4 years, half the length of the marriage. There's no argument about it. It's going to be 60% of the length of the marriage between 10 and 20 years, and 75% of the length of the marriage that lasts longer than 20 years. So if you're married 30 years, you get 75%. I'm not going to do the math in my head right now. 75% of those years for alimony.
So 7.5 years if it was 10 years.
Right. So 30 years would be,
or 30 years
22 and a half years.
Okay.
Yeah. So, basically it kind of reduces down to a formula, which I think does have some benefit. It does help ease the litigation. And, typically in alimony cases, the way the statutes are written now, instead of having hard line formulas, because there are often problems if you kind of don't fall into the way the formula was written. Usually there's presumptions. So it'll say, okay, like right now, if you're married, over 17 years, there's a presumption in favor of permanent alimony. You can rebut that presumption. Here, these are more hardline formulas. It goes on, and then of course there's a wind down period in certain circumstances that allows people to retire, because that's obviously a big issue with permanent alimony. There was a senator who did try to introduce an amendment to the bill to not have it be retroactive. That did not pass, and that's really one of the biggest concerns and biggest issues with the bill, frankly. Because these are contracts. So you're basically interfering with people's settlement contracts that they already entered into and that they're relying upon. And while, typically something like this probably would benefit one party on one side of the contract, there is a constitutionality issue, and that was raised previously, that you're now interfering with previously contracts that were previously entered into between private parties. I'm sure that's going to be raised. So a lot of pushback on the retroactive portion of the bill. Still have some pushback on the 50-50 time sharing portion. They're arguing that it guarantees more litigation and it will be ugly litigation, which is kind of counterintuitive when you're thinking, okay, this bill says there's going to be a presumption that time sharing is going to start at 50-50. And so what the opponents to the bill are basically saying that, if in the cases where one party really shouldn't have 50-50 for one reason or another, it really forces the other side to come out of the gate swinging, really have a, drawn out, dirty, mudslinging case because they have to come to the court with all this information to immediately rebut that presumption. Interesting way of thinking about it.
Yeah, and I do like the idea that the way that they're formulating the length of the alimony in this though is able to be calculated by, everyone. Like it's a known number, I guess, that everyone can see. Whereas before it felt like wasn't the way that the numbers and everything, wasn't it just like they plugged a bunch of numbers in and that's how they spit everything out?
So that's child support. This
Oh,
is
that's
this is
right.
time sharing or custody. So here they're based. So right now, time sharing in Florida, there's no presumption. It's based on the best interest
Right.
of the child or of the children. Here, this would start with a 50-50 presumption, meaning equal time sharing before, and then if you wanted to have unequal time sharing, you'd have to rebut that presumption essentially. You'd have to bring some evidence to the court to rebut that presumption to show why you believe the court should not be awarding equal time sharing in that case. So the opponents of this bill are basically saying, well, that means right out of the gate, you're gathering all the evidence, gathering all the photographs, and coming out swinging, which is going to make more litigious litigation, more ugly litigation that may not be good in those cases.
I get that point too.
Yeah, I do. That it certainly makes sense in that end. However, there's also a lot of cases where probably you could argue the exact opposite. Basically, there's cases where it should be a 50-50 time sharing, and people are already, because there is no presumption, they're being difficult, they're not agreeing to it, just to delay the proceedings or because they want to be difficult or try to withhold the children from the other side. So there's always two sides to things like that, but I understand the point they're making there.
Yeah, but I think in the way that I would see it, I don't know. I just think that yeah, when you start out with like an even score, right? It's like
Right.
like, and I don't want to think of it like that because it doesn't. You don't want a divorce to have that kind of mentality, but it's just something that we see a lot. Best case scenario is when it's an amicable, and in a 50-50 situation, this actually would be great. When if it's couples that are both on the same page with everything. But if it's not a clean divorce, you're going in with the mindset of okay, it's 0-0. I got to get mine.
Well, here's really the reality of it, I think, is either way, whether there's a 50-50 presumption or it's best interest of the children as it is now, if one party is seeking to have more time sharing, more custody, it's going to be a battle.
Yeah.
It's going to be ugly. Whether that ugliness starts out early on or later in the case, it's just going to be a battle because obviously they don't agree. They have very different perspectives on it. So I don't know that it necessarily matters whether there's a presumption there or not, because even with that presumption, you're just going to fight harder essentially if you don't want the other party to have equal time sharing, right? Because that's typically what we see. We see a lot of cases where people come in, they're very concerned about the children, they want to set up a schedule that works for the children. And in those cases, they're usually not so worried about 50-50. They're worried about a schedule that works, right?
Right.
Because, I mean, technically, with 365 days, there's really no such thing as 50-50. One person always has one
One
more
more.
overnight,
Yeah.
right? So
Except on leap years.
there you go. But in those cases, they're just concerned about the schedule, making it work, and those people typically work very well together to accommodate changes and things like that. Then you have other cases where they're going to fight each other over every little thing, including the children. And sometimes there's legitimate reasons to that. Sometimes there's not. Obviously, we only encourage them to fight if there are legitimate reasons, because otherwise, it's not going to go real well for you in court typically. Um, but when you come in, you have to lay out those legitimate reasons up front. And as I've talked about on this show before, usually those reasons are going to be drug or alcohol abuse, physical abuse of some kind, mental health issues, or that their job just doesn't allow them to have the time sharing to be equal. Essentially, they have some sort of crazy job schedule that just doesn't allow it.
And so at this point now, how much longer do we have to wait this out? Do you think it's just going to go up until the deadline? Do we think it's even going to get a vote or a signing by the governor? Like how does this play out?
Well, the end of the legislative session is right around the corner. So
Right.
it's March 11th. So
Yeah.
I think this might die on the Senate floor, to be honest with you. If they, given how much debate there is about it already, I don't see it getting passed. I've been wrong before, could be wrong again. Um, but we'll see if it makes it out of the Senate floor before March 11th. If it does, then it would be headed to the governor's desk to see if he vetoes it again, um, or if it passes and becomes law. If it does become law, it would go into effect in July.
Which at the time you're listening to this, on March 11th, is this Friday.
Yeah, so right around the corner.
Yeah, it doesn't seem like it will get passed, which is interesting because it started out looking like and we said it right. If you go back, you can go back and listen to these past shows. You can check them out on YouTube at DeWitt Law. You can check them out Facebook at DeWitt Law. Anywhere you can find podcasts, you can just listen to them as well. Whatever you want to do.
Oh yeah.
But we talked about when the bill first came out that it looked pretty clean cut and that it was something that would make it all the way through. And you mentioned that there's a chance that things could get thrown in and shake things up, and that's what we saw unfold.
And that's what's always frustrating, I think, about this process is, as we've talked about, I think most people agree that there needs to be some sort of alimony reform. The statute's just outdated at this point. It needs to be reformed to a certain degree. But then all these other things get tacked on there, whether it's deliberately to kill the bill or not. I don't have enough insight to know that. But then obviously it makes it more difficult to pass something that maybe most people would agree on because these other issues are now tacked on and riding on the coattails of the bill.
That's good stuff there, Mo. Appreciate that. We'll go ahead and take a quick break for the 3 big things you need to know. We got plenty more show on the way. You're listening to the DeWitt Law Review on WDBO. If you want to go ahead and leave an email for us to answer on the show, you can send those into ask@DeWittLaw.com if you have any curiosities, questions, maybe something to follow up on this alimony reform bill, or just, your own legal questions. Send that in, ask@DeWittLaw.com. That is ask@DeWittLaw.com. Plenty more show coming up. The DeWitt Law Review on WDBO.
I was visiting the local resort when I had an unexpected slip and fall. I reached out to the DeWitt Law Firm and was put in contact with Philip Wayne. Initially, the insurance company offered me a lowball amount, and I was able to secure over 10 times that amount from Philip Wayne and the DeWitt Law Firm. I'd like to thank them for all their hard work and recommend them to anyone who's looking to have an attorney. If you're injured on the go, just call Mo.
This is the DeWitt Law Review, WDBO 107.3 FM and AM 580, Orlando's news and talk. Chris Crawford and Moe DeWitt with you here on this Sunday. And Mo, let's go ahead and jump right back in there because we have a little bit more to get to with this alimony reform bill. You had one more point you wanted to make about it.
Yeah, I mean, something that kind of bothered me about one of the things one of the senators who I think they support the bill, said is, and this is their quote, "What happens is some people want to retire and it is non-modifiable and they're stuck. And it's sad on their end." He said they're out there working until they're dead. And so the issue I have with this statement is he's saying that it's non-modifiable. And the only way alimony is ever non-modifiable is if you agree to it. A court actually cannot award permanent non-modifiable alimony. I've appealed this before. I've gotten it overturned before by the appellate court. So to say that is somewhat deceptive because if the alimony is non-modifiable, that means the person paying the alimony agreed to it. So if you're out there and you're paying alimony, remember it's always modifiable. And if you have a change in financial circumstances, you want to file that modification as soon as possible. What this legislation is really looking to do is to eliminate having to file that modification because that's a whole other procedure. You have to go back to court. It is a headache. It's basically another lawsuit. It's still part of the divorce case, but it's basically like starting a whole new lawsuit. So, if you lose your job, if your income decreases, if you're at retirement age and you want to retire, those are issues where you'd want to file a petition for modification and get that alimony modified as soon as possible. And as we've talked about before, it's important that you file that petition as soon as possible because the judge has the ability to go back to the date you file it to retroactively modify your alimony. So if I file it today and it may take a year to get to trial, the judge can go back to today and say, for the last 12 months, you don't owe that alimony or your alimony is reduced down to whatever amount it is. So that's why it's so important to file that as soon as possible. And I often see people who call us and say, yeah, I lost my job 6 months ago. I'm now in contempt. I owe all this alimony. I just never got around to doing anything. And there's not much you can do at that point,
Right.
except file it, the day they call and say, okay, we can look at this point going forward. There's nothing we can do for the last 6 months. So even if it's a situation where you go and file it yourself and then hire an attorney later, get that filed, because alimony in Florida is pretty much always modifiable as long as there's a substantial change in circumstances that was not anticipated at the time of the final judgment.
And that's what I was going to say. As long as there is a substantial change in circumstances, which we've seen happen before, and happen, like you just said, if you lose your job, it happens to everyone. It's something that drastically changes the amount of money that you are making and your ability to probably pay that alimony. So yes, you can modify that, but you got to do it, as Mo said, just as soon as possible.
Yeah, that really is the most important thing. That's the thing I see people make mistakes about all the time is things aren't going well in your life, obviously.
Hey, you're just in the dumps.
You want to bury your head in the sand, not deal with it, but you just end up getting yourself in more trouble by doing that.
Yeah, exactly. Good stuff there, Mo. Appreciate that little tidbit. If you want to join into the show and you have a question for Mo, again, you send those emails to ask@DeWittLaw.com. That is ask@DeWitt Law.com. And don't forget, check out Mo on social media at DeWitt Law Firm, Facebook, DeWitt Law Firm, Twitter, whatever it might be, Instagram, TikTok, whatever you got, go check Mo out. Does a lot of fun stuff, a lot of cool stuff on all those social platforms. We got another half hour of the show coming at you here. We got some emails to get to. We got some more articles to talk about as well. You're listening to the DeWitt Law Review on WDBO 107.3 FM and AM 580.
Here's a little attorney secret for you. Hiring any attorney is always better than hiring no attorney. I know every day you get inundated with attorney ads on the radio, on television. Everybody's saying, hire me because I do this, or hire me because I do that. At the end of the day, if you just hire an attorney for your injury case, in my opinion, you're always going to do better. Yeah, the insurance company does know the attorneys who go to court. They know the attorneys who are going to fight them. And they do know the attorneys that are going to accept the last best settlement offer. But at the end of the day, if you don't hire an attorney for your injury case, in my opinion, you're always going to lose.
You're listening to the DeWitt Law Review on WDBO 107.3 FM and AM 580, Orlando's News and Talk. Chris Crawford and Mo DeWitt with you here on this Sunday morning. And Mo, we've got a lot of interesting stuff to get to here. So you've got another kind of article or tidbit or story. What do you got for us? Because you never tell me what it is. You just kind of spring it on me, which is always fun.
For. I mean, while the Florida legislature is in session, I try to bring up or find kind of the interesting family law bills that I think people might be interested in. And so this is kind of a unique bill that's been making its way through the legislature regarding grandparents' rights. And so typically in Florida, grandparents really don't have any rights unless the parents are just missing. And so this bill seeks to basically give grandparents some rights in some kind of limited circumstances. And so, to kind of understand this bill, I think you have to understand the history of where this bill comes from, essentially. So back in 2014, I want to say, 2014, there was a professor at Florida State University College of Law who I saw when I went there, and I didn't have his class, but I certainly knew who he was, by the name of Dan Markle. And in 2014, he was actually murdered in his driveway. And so he was going through a divorce at that time, and there were suspicions that his wife's family basically hired a hitman to come and kill him. And I think some people were arrested. I don't think anyone's ever been convicted of his murder that I know of. But his family has now moved to have this, what they're calling the Markle Act, pushed through as law. And basically what it would do is it would allow grandparents and step-grandparents to petition for visitation, but only after one parent has been found criminally or civilly liable for the death of the other parent. And to my knowledge, that has not happened in this case, but I would assume they believe that they could find the other parent civilly liable for his death. Just like in the O.J. Simpson case where he was convicted civilly, they could sue her for wrongful death. I'm guessing they believe that they would win that case, and then that would allow them to get rights under this. And so if that happened, a court could overcome the presumption in favor of grandparent visitation if it finds that doing so is not in the best interest of the children. So even if it's not in the best interest, they don't have to award it. But if they're found civilly or criminally liable, they can award visitation to the grandparents. Because my understanding is what has happened here is, Professor Markle at the time of his murder was going through a divorce. And allegedly, the wife's parents believed that Professor Markle was trying to keep the children away from the wife and them. And so they, again, I have to say allegedly a lot
Allegedly,
in this scenario, hired a hitman and had him murdered. And so since his death, my understanding is that Professor Markle's parents, the grandparents on the other side, have not had any interaction with the children, have not been able to see the children, have not been able to speak to their grandchildren. And legally, they have no rights to do so because grandparents really don't have any rights in Florida unless both grandparents are missing. I'm kind of saying that loosely. There's specific factors that have to be met, but usually both parents have to be missing in order to give the grandparents rights. So they're now, they've been lobbying for this bill to essentially give them an avenue to try to get some rights to their grandchildren after their son passed away because they haven't been able to do that. My understanding is the wife, the mother of the children, moved out of state, took the children with her, and has basically cut off all contact with her others or with the children's other set of grandparents. And so that's kind of what led to this bill, which is now it's actually had pretty good support going through the legislature. The House voted on 112 in favor, 3 opposed, and could become law here, relatively quickly in the next couple of weeks.
So in a way, it would almost give grandparents parental rights in like in a long roundabout way.
Sort of, but only it gives them visitation rights, right? So it would
Okay.
give them the ability to basically they'd have some sort of court order that say you get to see the kids every other weekend or 2 weeks during the summer or whatever it may be. Whatever you argue, just like in a paternity or a divorce case on a parenting plan, it would be the same thing, but with grandparents. But again, it is in the very limited circumstances where the other parent has been found criminally or civilly liable for the death of the other parent. So it's a pretty
Yeah.
narrow parameter that would open the door to allow to file a case like this.
Has there been a lot of instances of something like this happening? I mean, I don't know if you would know or not off the top of your head.
Well,
but,
I certainly don't know.
It just seems like a very specific, detailed bill. Like it seems very, very like the circumstances of everything.
Well, I think statistically, and someone out there correct me if I'm wrong, but I think statistically, your spouse is most likely to murder you.
Oh, it's true. My
statistically.
fiance jokes about it all the time.
Right, exactly. So,
That's
if
why I
you're,
hang out
if
with
you're
you just in
asking,
case. Yeah, if
does
you ever
this
go
happen?
missing, you know why.
Right, exactly. But if you're asking, does this happen often? I think that answers your question. It probably happens more than we know about or hear about. But typically, if it happens in those situations, we just never hear that the grandparents get cut off, which is what happened here, and which is why they've now petitioned the legislature to try to give them the ability to seek some rights.
Well, so now let's say that this bill goes through and they get some visitation rights, and then let's say that the wife is they find some evidence that ties her to this alleged crime, and she ends up having to go. What happens? Like she goes to jail. What happened? Because this bill's in place now, do the grandparents possibly have a right to take that child in?
So let me back up a second. First, before they would be able to petition the court to get any sort of rights, they would have to show that the wife was criminally or civilly liable for the father's death. So
that's right. Yes.
in this case, my understanding is it's really the wife's family who is the alleged suspect here. I don't know that they have any information showing that the wife had any direct knowledge of this alleged plan. But first, they would have to, I would guess they would most likely probably file a civil lawsuit against the wife, trying to find her civilly liable, because that's a lower standard than the criminal charges, and she hasn't been charged criminally as far as I know. So then once she was found civilly liable, or if she was found civilly liable, then they could go and petition the court to give them some rights, to give them time sharing of some kind, under this bill essentially.
What if and if she was found criminally?
Same thing would occur. Now, in that scenario, then she may be going off to prison
Right.
or something along those lines, and then it would that would really open the door for the existing grandparent rights where both parents are kind of missing, as I said, or not in the picture for whatever reason. Then they would have to bring the grandparents in, and then it would probably be a battle between the grandparents as to who got time sharing or custody of the children.
Yeah, that's an interesting one. I guess that it is one of those things where if you think about it in the way that you said it, where a lot of the times the spouse is the one to The that it yeah, that I mean, I'm it just that would be the instance, right? That all that the person who did it may want to try to keep the child for themselves in that type of way.
Yeah, I mean, it's a unique set of circumstances, a unique set of facts in this case, obviously. And so I don't know how often it would, come up and be brought in front of a court. It obviously opens the door for it to happen, where before there was really no option to do that. But there are certainly some steps that have to be done before that, and whether it's criminally liable or civilly liable, there has to be some sort of showing that they were involved in this murder plot, which, as far as I know, in this case at least, has not happened to date.
Can you? And I'm just curious. This is kind of offhand of this, but can you remember any bill that was super specific that didn't get through, or just kind of you remember seeing it come across and just wow, this is a very, very oddly specific bill for an oddly specific case. This doesn't seem like it would be something that'll get passed.
Yeah, there's definitely ones that pop up here and there, and we always say bad facts make bad law, right? Because they become so specific that it's really a just too unique of a circumstance. There was one actually recently we were talking about, maybe a few months ago. There was a bill that it basically favored a local local film school, and it was so specific that it gave only them tax breaks. It was like a college that primarily dealt with the film industry and so on and so forth, where clearly a lobbyist or someone had proposed this bill solely to benefit this one institution. And so I think that's where you kind of see it more. But I do think, bad facts often make bad laws, because you have such a specific set of facts, and then when they're applied across, a broad cases where the facts don't exactly meet the facts that they were originally intended, it can make some bad laws that could have some, adverse circumstances in the long run. But yeah, we certainly see kind of weird, off the wall proposals every once in a while.
I think it's just especially interesting, just the juxtaposition of the bill that we've been talking about and the alimony bill that was very straightforward and yes, this looks like it's something that'll be very solid and easy. But then with everything thrown into it, now it's well, what are we doing? Whereas then you have a very oddly specific bill that's I don't get why, but oh yeah, it makes sense. Okay, it just
right.
The way that the process is just very fascinating.
Well, and this is on the alimony side, you have kind of the Florida family law section. You have kind of larger groups that are petitioning for or against the bill. Here, you really have one set of grandparents who are pushing for this bill based on the circumstances of their life, and so I think that's why you see it being kind of so narrowly tailored to what they're experiencing.
Yeah, that is interesting. I'd be curious to kind of look up more past bills that have just had, I'd just be curious to see the ones that were just something about the way you're supposed to cross over the railroads during the day or something ridiculous like that.
Well, usually whenever a bill is named after somebody, and I'm not saying those bills are bad by any means, but usually when it's named after somebody, it's coming from a unique set of circumstances where that bill is kind of in honor of that person. So, and I know there's a lot, I can't think of them off the top of my head, but usually if someone is, murdered or, they put a bill in place kind of in honor of them to protect future people from, experiencing the same thing they went through.
Oh yeah, no, I get that. I'm just saying I want somebody who just did something like somebody who did something dumb, who was trying to cross over the railroad tracks when the arm came down and they just didn't notice and it hit them in the head. So they tried to file a bill about something with, I don't know. I'm just trying to
the Crawford Railroad bill.
Yeah, exactly.
Yes.
For somebody who just got upset about it one day or whatever, I think,
Understood.
yeah, because you have the Mio Marcano bill, which is great, about the background checks
exactly.
and everyone. That's awesome. That's a good bill. Those are the ones we should have. I just want to go on a deep dive and find the ones from the people who just got upset about something trivial and said, I'm going to write a bill and try and pass this.
Well, they would have to get a legislator to support them in pushing that through. So,
hey, money talks.
All right.
We got one more segment of the DeWitt Law Review coming up here. You are listening to DeWitt Law Review, WDBO 107.3 FM and AM 580. Don't forget, check them out online at DeWittLaw.com. You can also give them a call at the office. Schedule an appointment, 1-800-DEWITT-LAW, 1-800-339-4885. Also, check them out again online, DeWittLaw.com. You can submit case evaluations there. You can also check out some of the past archive shows. We got the Moe Pro Tip of the Week coming up, the DeWitt Law Review on WDBO 107.3 FM and AM 580.
I've told you before, I'm going to tell you again. Right here's a check for $25,000. Initial offer was $7,000. On average, with an attorney, you get 3 times more than those who go at it alone. Injured on the go? Just call Moe.
Final segment of the DeWitt Law Review coming at you right here on WDBO 107.3 FM and AM 580, Orlando's News and Talk. The final segment, but the favorite segment, of course, it's the Moe Pro Tip of the Week. Moe, what do we have?
So I'm going to tie this one into a bill that's also currently making its way through the legislature that deals with sovereign immunity. And basically, sovereign immunity is if you have to sue the state or governmental entity. So, for example, let's say you get hit by a Lynx bus or something along those lines where you're basically suing a governmental entity. In those cases, currently, there is a limit on damages, meaning that's what we call sovereign immunity. Basically, it limits the amount of damages you can sue the state for, the governmental entity for. And the idea is because we don't want those entities to go bankrupt. So right now in Florida, the limits are $200,000 per person or $300,000 per accident. So even if there's 10 people involved in an accident, multi-car pileup or something like that, it's still $300,000 per accident for the entire thing. Because that's what sovereign immunity says. That's what the state legislature says. Only in very limited circumstances can you get around that. Basically, you have to petition the legislature to approve your individual settlement, pay you out. Those are typically only in catastrophic cases, and it probably takes about a decade. So, basically, you're pretty much stuck with the limits. Right now, they're trying to increase that to $400,000 per person and $600,000 per accident. At one point, they were proposing $1 million and $3 million. It sounds like right now the bill is at $400,000 and $600,000 respectively. So we'll see what happens with that. But the pro tip of the week is, guess what still applies even if there's not enough coverage from the state? That's your uninsured motorist coverage. And that's why you want to make sure you have uninsured motorist coverage on your policy. Because if you do get into a catastrophic accident with a governmental entity, you are limited by these caps. But if you have uninsured motorist coverage on your policy, then they would step into the shoes of the at-fault party to cover any additional expenses or bills that you would have beyond that, or potentially would have beyond that. So always a good idea. Check your policy, make sure you have it. And there is a difference between stacked and non-stacked coverage as well, which we've talked about before. You can go back to past shows to listen to that, or shoot me an email if you want more details. I'm always happy to, if you have questions about your insurance, your car insurance, you can always email me, ask@dewittlaw.com, and always happy to give you some free advice on that.
I did not realize that was how that worked with government and like that. Like,
oh yeah, I mean, because you'll see cases where, and we've had cases in the office before where, I'll try to keep the entity names out of them, but basically a large truck for a county company essentially just rear-ended and destroyed a vehicle. The person driving was texting. Person had to be airlifted out of had multiple spine surgeries, couldn't perform their job anymore because their job required them to do some lifting. They just couldn't do it. They had to completely switch careers. A case where that person had $500,000 alone in just medical bills.
Yeah.
Not to mention lost wages and pain and suffering and everything else. But because it was a governmental entity, they were limited to that $200,000 per person, $300,000 per accident.
Well, and yeah, imagine if it was more cars in that accident, right? Like if there was a couple more cars in that.
And there were more people in the car that was hit as well. So it wasn't just her.
Wow, very interesting. But again, yeah, a good pro tip of the week there. Another reason that you want to have that uninsured motorist coverage here. It's just something that, we harp on and we talk about a lot here on the show. But there's a reason that we bring it up and we harp on it and we talk about it a lot on the show. And it's because it is very important for you to have, and it could help you very much in the long term if you were to get in some sort of accident, which of course we hope would never ever happen. Moe, appreciate it very much. Thank you.
Thank you.
Show as always, and everyone listening, we appreciate you tuning in. Don't forget, give Moe a call at 1-800-DeWitt-LAW, 1-800-339-4885. Also check out online DeWittLaw.com. You can submit a case evaluation there if you'd like to. You can check out some of the past archive shows. It's there. You can also check out the past archive shows. Facebook.com, also on YouTube. Just search DeWitt Law Firm, and you'll go ahead and find those past shows. You can listen to all the stuff that we talked about with that alimony reform bill in much more deeper detail with kind of the whole timeline of events, which is really interesting to kind of see how that bill has come along to where we are now, where we're 6 days away from it probably just sitting on the floor and nothing happening with it. Just very, very interesting. And of course, don't forget, send us your emails, ask@DeWittLaw.com. That is ask@DeWittLaw.com. For Moe DeWitt, I'm Chris Crawford. We'll be back same time, same place next week. Everyone have a great rest of your Sunday.